It's a pleasure to see all of you here. I have, over the last couple of years, watched the activities of the Center for the Law and the Human Person unfold here within the law school. And my colleague Elizabeth has done some wonderful work, and it's a pleasure to have you here now for our public debut and to host this conference. And I hope to see you again many times in the years to come as the work of the center unfolds. It's a particular pleasure to welcome Elizabeth Schiltz. Over the years, I have watched her at conferences and online lead discussions of the interplay between Catholic social thought and areas of law. And as someone who teaches, I think she's done a wonderful service to law professors to get us thinking about those connections. And she's been particularly eloquent in the connections between law and the dignity of persons with disabilities. So I'm particularly delighted that she's here to speak to us about the discordant notions of human dignity undermining the aspirations of disability law. Just a little bit about Professor Schiltz. She is professor and interim associate dean for academic affairs at the University of St. Thomas School of Law. Born in Frankfurt, Germany, Professor Schiltz graduated magna cum laude from Yale University, received her Juris Doctor from Columbia Law School, where she served on Columbia Law Review. After law school, she spent a year in Germany as a Robert Bosch Foundation Fellow. Then she was in private practice for 9 years at law firms in Washington, D.C., and then later in Minneapolis. From 1996 through 2000, Professor Schiltz was a member of the faculty of Notre Dame University Law School, and then she became a member of the founding faculty of the University of St. Thomas Law School, which opened in the fall of 2001. She teaches classes in contract, sales, consumer law, and disability law. More recently, she is the founder of the Special Education Clinic at the University of St. Thomas Law School. Her research interests include disability rights, consumer law, and feminist legal theory. Professor Schiltz is the secretary of the Board of Directors of the L'Arche USA, and she is a member of the Board of Directors of the National Catholic Partnership on Disabilities. She and her husband Patrick have been blessed with 4 children, 2 children-in-law, and 2 grandchildren. It's a pleasure to welcome Elizabeth Schiltz to join us today.
Thank you, Lucia, for that kind introduction. We have been friends for a long time, and it's such a pleasure to have an excuse to see her again. I am so honored to be part of this inaugural conference of this Center for Law and the Human Person. It's dedicated to exploring how the Catholic intellectual tradition can be applied to the absolute crucial task of preserving human dignity. I'm filled with awe at the contemplation of the things that this center is going to be doing under the able leadership of Elizabeth Kirk, and I want to thank you all so much for giving me a chance to be here at the beginning of this. This talk is going to be very concrete, so I'm going to frame it with something that's a little abstract. And I want to start off thinking about what's the purpose of laws, right? If we're talking about rightly ordered law, why do we have laws? What do they do? Legal philosophers have identified these kinds of reasons that we enact laws, these kinds of purposes, things that we're trying to do when we enact a law. And of course, this last one here, changing society or individuals, the use of law as an instrument of conscious social change, much the theme of Mary's talk, it has a long and venerable jurisprudential tradition, right? From Plato, Aristotle, Aquinas, Rousseau, and Thomas Aquinas identifies, right, the purpose of the law is to lead men to virtue. More contemporary philosophers sometimes call this the educative or expressive function of law. The legal scholar Cass Sunstein, he suggests that the expressive function of laws can be understood in 2 different ways. Sometimes the expressive function of law is intended to be norm shifting, changing the way that we influencing social norms and changing social norms. Again, much the theme of the last talk. Sometimes, though, he suggests that the purpose of the law is because it's intrinsically valuable that a certain statement be made. Intrinsically valuable for the relevant statement that is being made. And this is a quote, right? A society might, for example, insist on an anti-discrimination law for expressivist reasons, even though it doesn't really know if it's going to help members of a minority group. A society might endorse or reject capital punishment because it wants to express a certain understanding of how we should treat other people, not because they necessarily think it's going to do something one way or another. Civil rights laws are commonly understood to express a very strong, to perform a very, very expressive functions. Civil rights law, anti-discrimination laws are attempts to address centuries of discrimination, unjustified stigmatization of protected groups. And in order to really reach these entrenched kinds of stigmatizations, the laws are attempting to establish new norms, new ways that we should be treating one another. But they also understand that to accomplish the new norms, it's really important that we get together as a society and express a collective statement, about the equal dignity of all. Now, the Americans with Disabilities Act is a civil rights act that has a very, very strong expressive function. It was enacted in 1990 with the broad aim of eliminating discrimination against individuals with disabilities. It's a really powerful and far-reaching law. It goes much further than most civil rights legislation. It not only prohibits discrimination, but it mandates accommodations. It mandates imposing affirmative duties on parties to make reasonable accommodations to ensure that people with disabilities can access the things that we think that are part of being a citizen in the country. The accommodations can impose significant burdens and costs on people. Both the prohibition and the mandates express a social consensus together that people with disabilities deserve equal treatment, but that also they're going to need some help in order to equally participate in our society, right? So this is my question and my concern today. This is what I'm going to be talking about. Has this expressive function of the ADA come to be, or has it always been, perhaps, so inextricably bound up in a flawed idea of the human person that it's actually incapable of protecting the most vulnerable among us? Is the message that's being sent and insisted upon by the ADA and disability rights advocates discordant with the aspirations of what we're trying to do with our disability laws? What is the flawed notion of the human person that underlies our disability laws? The dominant narrative of our modern post-Enlightenment liberalism, the common vision that shapes our laws and our social structures, is that our dignity lies in our autonomy, our rationality, our capacity for self-definition. Now, the Catholic intellectual tradition disagrees with that, right? We insist that what we all share most fundamentally is our vulnerability and our dependence on each other. And in fact, that is where our common human dignity lies, our common vulnerability. This critique of the more modern vision has been launched by various kinds of parties, including philosophers arguing for more progressive laws in different areas, feminist, legal scholars. But the group that has the most immediate stake in this critique is obviously the disability community, because a lot of people with disability, if that's the definition, that our dignity lies in our rationality, some of them don't possess rationality. So they've lost already, right? And even those who can pass that first hurdle are probably more keenly aware of their own vulnerability and dependency than people without disabilities. there can be no doubt that people with disabilities are treated much better now than ever before in history in the United States, and that people with disabilities in the US have greater legal rights and protections than in most other countries across the globe. But I'm going to argue today that these laws that we have on our books aren't as strong as your average postmodern liberal humanist likes to think that they are, and what's more, they're seriously flawed because they're structured around this false but dominant vision of human dignity. And my talk is going to have 4 parts. First, I'm going to talk about showing how the ADA, the Americans with Disabilities Act, is very significantly shaped by the values of autonomy and independence. The ADA does not do a whole lot for those with disabilities who cannot achieve a certain basic level of autonomy and independence. Next, I'm going to talk about something that's not widely discussed because it is very boring and complicated, but more importantly, I think because it is inconsistent with the values of autonomy and independence that shape our public proclamations of disability rights. The truth is, the lives of people with disabilities are affected much less by the ADA than by the complex set of laws and policies of the welfare system. That's what provides the real day-to-day support that a lot of people with disabilities need in order to function in an integrated way in our society. And that entire system is structured around the opposite of autonomy and independence. It's structured around proving that you are dependent and that you are vulnerable. And furthermore, that structure is wholly inadequate to fulfill the ADA's promise of autonomy. This is my third point. In reality, for the most part, the lives of most people with disabilities are radically dependent upon the support of their families. But that hard fact is largely ignored by the systems of support that we have for people with disabilities, because it is, of course, radically at odds with the grand vision of autonomy as everyone's ultimate goal. And because this is such an inconvenient fact, families have been left on their own to fill in the gaps in the social services systems that support people with disabilities, and this has become especially brutally clear during the years of the pandemic. Okay, so the final point then is that there's real and present dangers that are posed by this autonomy message of the ADA and disability rights advocates. There's continued pressure to enact legal reforms that are aimed at instantiating the values of autonomy and independence at the expense of some of the most vulnerable and dependent people in our society. And I'm going to give you 2 examples of how that dynamic is at work in jobs and in housing. So first, who does the ADA protect? When the ADA was enacted as to law in 1990, it wasn't the first or the only disability rights law. It was preceded by a series of other laws prohibiting discrimination on the basis of disability in various areas. One was the Federal Rehab Act of 1973, which prohibited discrimination because of disability on any program or activity that received any sort of federal aid. And it created some affirmative action programs for people with disabilities in federal agencies. One of the most dramatic stories in the history of the disability rights movement in the US was what was depicted here in these pictures. These were demonstrations and sit-ins by people with disabilities to finally pressure the Department of Health, Education, and Welfare to approve the regulations that implemented the Rehab Act of 1974. This was the occasion of the infamous Capitol crawl, right? These are people that use wheelchairs that abandoned them and their crutches in the bottom of the steps of the Capitol and crawled up the steps of the Capitol to dramatize their passion. This led to the enactment of the ADA. So back here again, so we had the Rehab Act of 73, then we got the Education for All Handicapped Children's Act, later the IDEA that was enacted in 75, the Fair Housing Act prohibiting discrimination in housing for people with disability, and then we finally got the ADA, and we've gotten amendments since then, right? So the ADA, though, it's the big kahuna of all of these laws. It's where all the action is, and it's divided into 3 parts. So let's look at them a little bit. Title III, that is the part of the law that requires the removal of architectural barriers and prohibits discriminatory eligibility criteria that would prevent anybody with a disability from accessing any public accommodation. This is what we probably mostly think about when we think about the ADA. It's what gives us ramps. It's what gives us big bathrooms, big, handicap accessible stalls. It gives us Braille Braille on our ATM, drive-up ATM machines. It's what gives us the features that we probably all use to open doors when we're carrying a lot of heavy things, or the curb cuts that we use if we're wheeling babies around in a buggy. That most visible aspect of the ADA, that clarifies the animating vision of the bulk of the advocates who pushed for the ADA. It was those people that I showed you in those pictures. Those were college-educated people with physical disabilities, intelligent, articulate, doing incredibly important work. These brave and committed activists, they truly changed the world for the better for all people with disabilities. But the law itself is clearly focused predominantly on helping those with disabilities who are realistically capable of achieving a productive, independent life to do precisely that. Let's look at Title I. Title I prohibits discrimination against otherwise qualified individuals in hiring, advancement, discharge, employee compensation, job training. This is also a powerful and wonderful piece of legislation. And I'm a huge fan of what it does to protect qualified individuals from workplace discrimination on the basis of a disability. But it has very limited application to the life of people with significant intellectual abilities, right? It prohibits discrimination against otherwise qualified individuals. And a lot of people with significant intellectual disabilities are not likely to meet that threshold. As interpreted, the ADA does not recognize as reasonable accommodations the sorts of support that many people with intellectual disabilities might need to hold a job. I don't think that language necessarily is compels this attitude of stinginess, but that's how it's been interpreted. For example, courts just have not been receptive to holding as reasonable accommodations the sorts of things a lot of people with developmental disabilities might need. In the EOC v. Hertz case, a district judge in Michigan conceded that a temporary job coach might be a reasonable accommodation to provide job training when somebody begins a job, but beyond just the beginning entry point, sort of a permanent job coach or permanent job support is not a reasonable accommodation under the ADA. In this other case here in the Second Circuit, a case involved a person with a physical disability, but the court here disallowed as a reasonable accommodation something that's often seen in supported employment arrangements involving people with intellectual disabilities, namely having two people share a job, perform the same job as one. Okay, finally, let's look at Title II. Title II prohibits excluding a qualified person with a disability from participation in services, programs, or activities of any public entity. This is hugely important. This covers voting. This covers access to courts, juries, treatment by law enforcement officials, emergency preparedness plans, U.S. currency, maintenance of public sidewalks. It's the section of the ADA that's most evenly applicable to all people with disabilities because it covers services that are crucial to all kinds of disabilities. This was the section of the ADA that the Supreme Court relied on in 1999 in this landmark case of Olmstead v. LC. That case held that it was illegal under the ADA. It was illegal discrimination for a state to keep people with disabilities in institutional settings if they had been judged competent to live in community settings. They said public entities have to administer their services, programs, and activities in the most integrated setting appropriate to the needs of these people, a setting that enables individuals with disabilities to interact with non-disabled persons to the fullest extent possible. This is hugely important in the ongoing fight for deinstitutionalization of people with disabilities, and it's called the Brown v. versus Board of Education of the Disability Rights Movement. But all that it does is tell states that they can't institutionalize people. It does not provide or do much to create alternative community-based settings to which these liberated people can move. So where do people with disabilities find these alternative living situations? That is a reality that the ADA simply ignores. Besides a place to live, people with disabilities often need support for what are commonly called the activities of daily living. These could be things like eating, dressing, feeding oneself, doing laundry, doing chores, handling money, transportation, shopping. To get that help, a person has to either be able to pay for it, or get support from the government to pay for it, or find a friend or a family member willing to do it for free. So let's think about this. Paying for it yourself, job income. The unemployment rate for people with disabilities is about twice as high as it is for people without disabilities, and 2022 was a landmark good year for people with disabilities. Workers that are employed with disabilities are twice as likely to be employed just part-time than others. And and we know that those unemployment figures only count people who are actively looking for jobs, people that are in the labor force. And nearly 8 in 10 people with disabilities are not even in the labor force, compared to 3 in 10 of people without disabilities. So income is a problem for people with disabilities for some other reasons that I'll get into later. But paying for yourself for that support is problematic for a lot of people. So what about Social Security? What about supplemental security income? If you can prove that you don't have assets of over $2,000 and $2,000, you don't have assets of over $2,000 and you have a disability, you can get SSI, which is currently at a rate of $841 per month, doesn't pay much rent or the care of, doesn't pay much in the way of wages for a care worker. So what about the federal Medicaid program? It's administered through the states. To qualify for assistance under the Medicaid program, you have to prove that you don't have the resources to pay for the services yourself. If you can prove that, Medicaid has to pay for you to live in a nursing home where you can get the help that you need for the activities of daily living. But most people don't want to do that, right? You don't want to live in a nursing home. So you can apply for something called Consumer-Directed Personal Financial Assistance Service. Instead of living in a nursing home, you can choose where you're going to live, and you can choose the people who are going to provide the care for you. This option accomplishes a number of really noble goals of disability rights law. It allows the person to be integrated in the community. It gives them some dignity and autonomy with respect to who's going to be taking care of them and their body. These programs are typically called waiver programs because the states have to apply to the Federal Secretary of Health and Human Services, HHH, for a waiver that lets them pay for home or community-based services as medical assistance. HHS is waiving the strict regulation that would govern the care of this person if they were cared for in a nursing home, because it ends up being cheaper and much more satisfactory for most people with disabilities. And that sounds good, right? Indeed, in the majority opinion in that Olmstead case, the Supreme Court took comfort from this. They said, since 1981, Medicaid has provided funding for state-run home and community-based care through a waiver program. Indeed, the U.S. points out that the Department of HHS has a policy of encouraging states to take advantage of the waiver program and often approves more waiver slots than a state ultimately uses. That is a bit disingenuous. The reality of the waiver program is that states don't have enough money to give everybody the funding that they might need to live independently, and most states have notoriously long waiting lists for people who want waivers to actually get them. Here are some from some surrounding states. The 2017 seems like a long ago, but that's the latest study that I could find on this. Virginia, how many people were on the waiting list? 12,000. Maryland, 35,000. Ohio, 68,000. Florida, 71,000. Texas, 281,000. Now, these numbers can be really deceptive. Some states allow people to get on the waiting list before they've been screened. These might be people who are not even eligible. And for example, in a study recently in 2021 by the Kaiser Family Foundation, they explained this. Ohio, which is up there with 68,000, had all of these people on their waiting list in 2018. In 2019, they developed a new waiting list assessment. Using that assessment, the state was able to remove people from the waiting list who didn't meet the waiver criteria and provide them with other Medicaid or state resources to meet their needs when appropriate. In 2020 and 2021, the waiting list was only about 2,000 people. But still, that Kaiser Family Foundation study, that same one, found that the number of people on waiting lists in the U.S. fluctuated from between 2016 and 2021 from 656,000 to 820,000, back to 656,000 in 2021. And in 2021, people on the waiting lists had to wait an average of 45 months to receive waiver services. up to 44 months from 2020. People with developmental disabilities had longer waiting times, 67 months. That's 5.5 years, okay? So even if you qualify for a waiver and you get off the waiting list, you have to find a place to live and you have to find people willing to do the care that you need, right? Although Medicaid lets you choose your personal assistants under the waiver program, the state controls the wages you're allowed to pay for your personal assistants. The Medicaid reimbursement rates are often very low, and these jobs typically come without any kind of employment benefits. The lack of qualified direct support personnel has been acknowledged as a crisis for decades, and the crisis has gotten dramatically worse during the pandemic. It's difficult frontline work caring for people who can be more susceptible to COVID than the average population, perhaps less able to engage in practices like wearing masks and maintaining social distancing. So as you can imagine, right, when you're dealing with a program as massive and complex as a federal Medicaid program that's administered by all 50 states in different ways, the web of laws and regulations and policies that govern it are massive and complex. But those laws are virtually never addressed in any of the timelines of disability rights that you can find on the web, or even considered when talking about disability rights, because these laws and policies do not fit within the narrative of disability rights in general. When I teach disability law, I chose a casebook because it did address these laws. It's a casebook that's 659 pages long and has 2 pages on all of this. Little note, 2 pages of notes, not even main text. So where do people with disabilities end up finding the housing and the support that they need? And the answer is families, right? That's a reality. That's an unacknowledged reality of life with a lot of people with disabilities. Most people with cognitive disabilities live with their families. A nationwide survey in 2001 showed 60% of all people with intellectual disabilities live with family caregivers. In my own state of Minnesota, 65%. In my state alone, NPR reported this past June that 170 group homes had closed since this fall. This was a headline from a local disability press. More than 170 facilities closed. Group homes were our answer to institutions. What happens to us now? Where do they go? A lot of them go back home. This is a picture of people protesting in front of the governor's mansion, looking for more funding for people with disability, for the care workers, for people with disability. And something that's really important to recognize is that living at home is a proxy for having all of your activities of daily care that you need help with provided by members of your family. A 2020 study trying to get the handle on all the situations with the Medicaid waivers surveyed stakeholders. They were trying to figure out, how do these people who are on the waiting list, what are they doing? How are they getting their needs met? And this is what they found. When asked how individuals manage their needs while waiting for services, interviewees most frequently cite support provided by family caregivers. Many family caregivers are unpaid, although some may be paid in waivers that allow for self-direction of services. We all know about the increased caregiving responsibilities of all parents during the pandemic, right? Well, during the pandemic, another thing that was closed were the day programs for people with disabilities, where people get supported employment or activities to spend some time during the day. When those closed down, where did the people with disabilities go? Maybe isolated in their group homes, but when those shut down, where did those people go? They went back home, and it was up to the families to find things for them to do all day, keep them safe, keep them sane. And many of the supported employment options for people with disabilities, they were closed as well. And same thing then. These formerly employed people with disabilities were living at home and being taken care of. Okay, so here's where I'd like to be able to say something uplifting. It's not all really that bad, right? There's hope on the horizon, but no, I can't, right? Because I have to say that I think in some ways things might be getting worse. How is this continued emphasis on autonomy, how it's compromising the support for a lot of people with disabilities? There are 2 disability law reform initiatives that dramatically illustrate the continued hold of the autonomy model and the ideal of autonomy in disability rights activism at the expense of those whose lives witness a very different vision of human dignity. One has to do with jobs, the other has to do with housing. Now, both of these originate in absolutely legitimate and noble movements to address historic abuses, horrific abuses of people with disabilities in institutions like Willowbrook that were funded by people doing for free the work of maintaining the institution, which also was quite a disincentive to actually provide any job training that might allow people to get jobs outside of the institution. More recently, though, and closer to my home anyway, in 2014, an Iowa jury awarded 32 men with intellectual disabilities $240 million for decades that they spent living in a decrepit bunkhouse run by Henry's Turkey Services in Atalissa, Iowa. They were living in this bunkhouse, locked up at night so they could work during the day, eviscerating turkeys for 41 cents an hour. That's not that long ago, and it's not that far away. So this stuff really is bad, and it still needs to be addressed. But do we really have to legally eliminate other arrangements that have nothing in common with that sort of exploration simply because they run counter to the autonomy-based notion of human dignity? Restricting employment options that don't conform to the ideal of autonomy is, I think, happening. Over the last decades, there's been a push to close what are called sheltered workshops. The settings where people with disabilities work together in some kind of a closed setting, doing work typically contracted for by companies, typically at less than minimum wage. And there are two aspects to the shelter. There's the physical shelter, they're isolated and segregated, but there's also a figurative shelter from minimum wage laws. There was an exemption from the minimum wage laws for people whose earning or productive capacity is impaired by age, physical or mental deficiency, or injury. Now, let me be clear. I fully support a critical and careful look at situations where employees are paying less than minimum wage to a person with disabilities who is capable of doing work at the same level as people without disabilities. And I fully support efforts to identify people who might be isolated in segregated settings who actually could get jobs in the community. There's no justification for exploitation by businesses like Henry's Turkey Farm, but not everyone with a disability is capable of that kind of work or is comfortable or safe in the hullabaloo world of commerce. And the pressure to recognize only one kind of work as legitimate, noble, enhancing of dignity is having the effect of eliminating work arrangements centered around a different vision of work. A vision of work as the ongoing participation in God's creation, having both an objective and subjective dimension as something with an intrinsic social dimension as well. In 2014, the minimum wage exemption was amended to add a requirement that no one under the age of 25 could receive a sub-minimum wage unless the state's voc rehab office certified that they were ineligible or unsuccessful at achieving competitive integrated employment. This concept here of competitive integrated employment, that's the gold standard for jobs for people with disabilities. And it has these attributes that are listed there. They're all great, right? They're all lovely. But it's just weird if you think about what's going on with that law. Where is it found? It's in the statute administered by the Department of Labor, but the provision puts the authority into the hands of each state's voc rehab office, which is regulated by the U.S. Department of Education. Not labor, education. And what's the idea behind limiting it to people under 25? It's supposed to capture people with disabilities right after they leave high school. So when they're maybe able to get some kind of a job, to stop them from being diverted into a sheltered workshop. So let's think about how would you get a certification to take a job that does not qualify. Every state runs things differently, but anecdotally in Minnesota, my state, voc rehab has to observe you failing in 3 different situations. That means voc rehab has to find 3 employers willing to let them use their work as a test site, and you have to try and fail at 3 different jobs before you can take a sub-minimum wage job. Just think what that means for the person with disability who has to go through this humiliating and time-consuming certification, regardless of how obvious it might be that they're not capable of competitive integrated employment. Realistically, how likely is that to happen, and how long is that going to take? In the meantime, what does this young person do while they're waiting to turn 25? Got any guesses? They're sitting at home with their families trying to find something for them to do. And the youth is prevented from taking part in potentially valuable training and job skill development in a sheltered, more supportive environment that might actually help them attain a real job. What's happening in reality is the creation of two classes of people with disabilities in the employment market, those capable of and those not capable of competitive integrated employment. Those who fail at competitive integrated employment are increasingly being left with no options. As settings that have the slightest resemblance to sheltered work environments are closed by state mandates or by regulatory obstacles or funding issues. In October of 2021, the Department of Education issued updated guidance on the criteria for what's an integrated employment location. It explained that typically found in the community, the second bullet point there, rules out any employment setting that was formed for the specific purpose of employing individuals with disabilities. It also rules out group employment settings, such as janitorial and landscaping crews, unless you can prove that this crew was not put together for the purpose of employing people with disabilities. The guidance does say that people with disabilities have the right to choose not to seek competitive integrated employment, but no voc rehab funding can be used to support that person. Instead, the voc rehab agency has to refer that individual to other community resources that may be able to assist the individual. Now, y'all are lawyers. When federal agencies issue regulations, they have to publish a draft and they have to get comments and then give an explanation of what they're doing. The discussion in the regulations that enacted this change to the minimum wage exemption was a textbook case of this blind adherence to the ideal of autonomy. The constant response of the agency to arguments about the detrimental effect this move might have on some people with disabilities was simply, well, the law says that people should have this kind of employment. Here's a quote. "We understand the concerns about the potential loss of needed disability-related and income-based benefits and the availability of sufficient jobs in the community. However, the law embodies the belief that with appropriate skills and supports, all individuals with disabilities can participate in the competitive workforce and achieve self-sufficiency. The Act, as amended, could result in more job opportunities becoming available to individuals with disabilities, including those with the most significant disabilities." Yeah, it could, but is it? This January, the GAO issued a report on the sub-minimum wage program titled "DOL Could Do More to Ensure Timely Oversight." That report includes a number of very significant and troubling findings. It suggests that eliminating the 14C jobs is not creating competitive employment for the workers. Relatively few 14C workers, an estimated 12%, engaged in competitive employment during the month of August 2021. It also confirms some of those problems that were signaled earlier. This is a quote from one employer. "Working more than a few hours a week in the 14C program interferes with necessary benefits and Medicaid that is necessary to pay for healthcare, medications, room and board for group home residents or other living costs. We work with a substantial amount of persons who live in group homes, and many have mental health and health concerns that require high prescription costs that they would be unable to afford if their benefits were cut. The reality is just wishing for competitive, full-time, full-wage jobs for all people with disabilities and asserting that it's the ideal doesn't create those jobs. And as this last quote makes clear, if a person with a disability is too successful at obtaining a high-paying job, they run the risk of losing their eligibility for SSI and the waivers that make their semi-independent lives possible. If this isn't a demonstration of the dissonance in our schema of disability law, I don't know what to call it. This is really troubling for me. I would really like not to be saying this or dissing this effort to try to get competitive wages for all people with disabilities. Just yesterday morning in a local newspaper, there was a big front page article about how they're trying to eliminate entirely the the sub-minimum wage exemption in Minnesota, highlighting just magnificent stories of two young men who had been in sheltered situations who are now finding really great jobs. I don't like to be speaking out against it, but the reality is what the reality is, and I know people are being left behind. And that article ignored another recent article from a couple of weeks ago talking about the huge waiting lists in all of the voc rehab offices for people that were looking for jobs. Okay, now just really, really quickly, housing options. There's a almost identical issue here going on with respect to the housing options for people with disabilities. The deinstitutionalization of people with disabilities was the single most important thing in the history of disability rights. But it's not enough to close the big institutions. You got to find places for people to live. And that happens mostly through the Medicaid waivers that I described to you. In the last couple of years, the definition of what qualifies as a home and community-based setting has been under fire. The HHS was under a lot of pressure to restrict it to any setting that has less than 4 or less people, that you couldn't have anything with more than 4 people living together that would qualify. They backed off. They didn't do that. Instead, they had this great little list. These are the kinds of things, qualitative things that we're looking for. But that pressure continues, and a lot of states are setting higher restriction, are setting like 4 people limits on the amount of group homes. And what's the practical consequence of this? I serve on the board of L'Arche USA. It's the American chapter of an international movement that administers homes, right, where people with and without intellectual disabilities live and work together as peers, creating inclusive communities of faith and friendship, transforming society through relationships across social boundaries. Many of these communities are finding it harder and harder to maintain the kinds of homes that they've maintained in the vibrant group housing situations in the face of these regulatory pressures that can make their homes economically unfeasible. The nascent L'Arche community in the Twin Cities, which is trying to form a community, is faced with a flat-out moratorium in Minnesota for new group homes, and they're looking to offer other things that they can create community with in people. This move is just it's so opposite what other non-disabled people are looking for in their own homes and situations. Would any of us accept that the ideal for our life is to live alone in an apartment? In Minneapolis, this new 2040 comprehensive plan for growth and development is to remove barriers and support innovative and creative housing options, multi-generational housing that supports large family structures, shared housing, co-housing, cooperative housing. A Harvard Wheelwright Architectural Prize Award was awarded in 2016 for work on collective housing in Brazil, Sweden, Russia, Korea, and elsewhere, reflecting a variety of approaches to organizing and distributing domestic spaces. One of the hot trends in real estate for hipster millennials, right? Co-living. We live together in family-like situations if you don't have a family, in common kinds of situations. It's just ironic, right? All of these movements are recognizing the value of mutual dependence and stronger networks of common life, and the isolation of the pandemic has made us all recognize that even more. So in closing, right, these are the major functions of law, and we all want to change society. We all want to change society for the better, right? That's a statement-making function of these laws. But when that statement is being reduced to one note, a note that's based on a false notion of the reality of our human condition, it risks creating a dissonance that drowns out the other purposes of the law, like ordering society or dispensing justice. But we all agreed that Mark was going to be dealing with justice in his next talk, so I don't have to try to do that here and try to define what justice might be for people with disabilities, so I'll stop.